Now, failure to adequately allege the relevant jurisdictional basis does void any attempted service, even under long arm statute. So Ms. McCarthy did make a statement in open court, or I mean, in his hearings, not court, in his hearing that this petition or this complaint exists. I'd like to see the complaint. In 1995, well-established law required the service of process of an initial complaint and summons within 120 days of filing. The 120-day limit to effect service of process, which was established by the Federal Rule of Civil Procedure 4J, we know that's called federalism, is to be strictly applied. Now, and if service of the summons and the complaint is not made in time, and the plaintiff fails to demonstrate good cause for the delay, the court must dismiss the action as to the unserved defendant, which would have been me. And that's Morales versus Sperry Rand, and that's 578 SO.2D 1143, 1145. And we don't have to continue to beat this dead horse, but I'm going to. It doesn't show successful service of process within the first 120 days of the DOR or Minister McIntosh filing his complaint summons. And by the way, the docket doesn't show any effort whatsoever of good cause for not serving it within the 120 days. In 1995, when this case was initiated, the law mandated that the court dismiss the action if it wasn't served within the 120 days, and there's no showing of good cause. Go to Hodges versus Knoll, that's 675 SO2D 248, and it says the trial court may not exercise its discretion to refuse to dismiss a case under rule that's 1.070I unless the record evidence of efforts made at the service during the 120-day period, which would support a finding of good cause under the rule, that still would not excuse you showing the court good cause. It doesn't, and by the way, it shows that the DOR did amend its complaint twice without leave of court, once on February 9th, 1998, and again on September 10th, 1998. The rule for amending a complaint under the rule I've already mentioned earlier, which is Civil Procedure 1.190A, only allows one amendment without leave of court. You can see Fusiller versus Markov, that's 676 SO2D 1053 and 1054. And as I stated before, a party may amend the pleading once as a matter of course at any time before a response to pleading is served. Otherwise, a party may amend the pleading only by leave of the court or by consent of the parties. You already gone to that. Well-established law required the court to dismiss the second amended complaint and vacate the default judgment entered by this court on July 19, 1999. This court held an amendment without leave of court. This court held that an amendment without leave of court or consent is generally a nullity, and that's Troso versus Florida. I guess it's Insurance Guarantee Association, but anyway, it's 538 SO 2D 103, 105, and that was the Florida 4th DCA. And by the way, the law requires that DOR attorneys, child support hearing officers, and the judges of 13, despite what they may think, to follow all statutory provisions and well-established laws regarding service of process. And that's, I don't want to butcher the name, it's Shelkis versus Sutton Hill Associates. And that spelling is SCHUPAK versus Sutton Hill Associates. And that's 710 SO2D 707, 708. And it's clear, strict compliance with statutory provisions governing service of process is required in order to obtain jurisdiction over a party. It's clear that that didn't happen. Well-established law determined that an order entered without subject matter jurisdiction is void. You definitely didn't have subject matter jurisdiction because you never pled, or at least in the record, there's no evidence that jurisdiction was ever pled, despite what Ms. McCarthy just said. But I'm going to hold her to that. And you can go to Cole versus State, that's 714 SO2D 479, 489-490. That's out of the second DCA in 1998, by the way. And the Florida DCA did hold that an order entered without subject matter jurisdiction, the second DCA did, is void. Now, we can go back to Rule 12.540 as well as 1.5404B. I mean B4. That states.
Well, I was about to ask you: is that the rule that you're citing as the basis for this emergency motion that you filed?
It's the basis for everything, that the underlying order is void. and I can challenge jurisdiction at any time. And the fact that everyone has put in such an effort to disregard the question of jurisdiction, we want to say it's res judicata. And the second DCA never addressed subject matter jurisdiction.
Sir, I made a finding on the merits in that previous order, and then also made a comment about res judicata. But go on.
Yeah, and you're wrong. It wasn't if it was litigated, show me exactly where it was litigated. That's not difficult, and you're supposed to be a hearing officer. You've injected yourself in quite a few of these hearings. If you have a witness, Mr. Denton, which I didn't know you were the attorney, have the witness come forward and produce the document so that I can cross-examine the witness as to the veracity of the document,
There's a previous finding by Judge Ayers regarding res judicata. There's a previous finding on your.
No, she did not. Judge Ayers cited the case. It did not apply to this case. She never addressed the 120-day service of process, and if she did, show it to me.
And Judge DePaul made a comment that res judicata appears to apply on the.
Appears. Tell him to prove it.